And good afternoon, everybody. I'm Aaron Connor. That means that's Frank Hemming.
Still here. Back after all these months. They still have me helping with these.
We are here together. We are talking Medicaid, obviously. And just as a reminder to everybody, it's not just Frank and I, or just Frank, Lou and I, or Lou and I, whatever combinations of that. We have a lot of attorneys in a lot of different places, but we all do elder law, estate planning type work. So if you need some help in our space, we have plenty of people to assist you. So this is not the first Medicaid Monday. We've done a number of these now. They are all available on our website at prolaw.com/Medicaid planning videos. You can see each topic, and if you have missed any of these, it's a good series. I think I could say that pretty easily.
You see a lot of me.
Yeah,
for sure.
So positives and negatives. But if you really need to know, or you need some basic information about Medicaid and probably why you're going to need us if you're going through these videos are very informative and can give you the background of what you're really going to need. So it's kind of a reminder. Frank, you want to give everybody this reminder?
Sure. Good news, right? We like to start off with good news because it's not always clear how much more good news we have to share with you depending what topic we're doing. But good news, income limits are up, asset limits are up as of the first of this year. So again, just as kind of the reminder, we've done this in just about every other Medicaid Monday video that we've done. But if you're a single individual, your income allowance is now up to $16.97 a month, which is up $743 from last year. If you're a couple, again, your allowance is up to $22.88 per month, which is over $900 of an increase. For asset purposes, if you're a single person, your asset limit's now $30,182, up from $16,800 last year, so up almost or over $13,000. And then if you're a couple at home with both spouses requiring Medicaid, then your number has gone all the way up to $40,821, which again is an increase of over $16,000. So again, we are always mindful of these are not the largest numbers. We understand that many of our clients struggle with trying to make these numbers work for them, but in all actuality, they are at least numbers that have gone in the right direction from just even a few months ago back in 2022 when they were substantially lower than the numbers that are here on the screen.
So today we're talking about denials and appeals. So why can you be denied? Well, you can be denied due to too much income. Don't see this one a lot.
No, I think I saw one of these for the first time in many months within the past few months from New York City. And while we did not agree with the determination or why they were saying they actually did put in writing that a client was denied due to excess income. The nice thing about this is you can typically solve this with trust planning, whether that's pooled trust planning, irrevocable trust planning, or a combination of both. So if you have questions about income trust and pooled trust, we did a Medicaid Monday about that. When our friend Sarah from NYSARC joined us. So if you want to go back in the series and check that one out, that wouldn't be a bad one to check out to see maybe how we would deal with an issue due to having too much income.
So due to assets, this happens certainly more frequently because sometimes there's a dispute about what's a countable asset and what's not, right?
Yep.
Not all assets count.
Yep.
Because if it were logical, you probably wouldn't need us to do this. But if you have a home with a spouse living in it, that's an exempt asset.
As long as I know that.
That's right. And not a great one to rely on long term, but can be relied on in the short term. There may be IRAs or 401ks or other retirement assets that are not in payment status. Well, that would make a otherwise non-countable asset countable, repairable very quickly. Certainly a lot of other things. If someone is claiming a caregiver child exemption, could be denied.
Sure.
If you're claiming, if we've done an audit, not we, but someone has done an audit and there are gifts that you haven't counted that Medicaid's going to count, then we have a problem too.
Right.
Which really rolls into the next one.
Exactly. Yeah. So the other piece for the asset portion that I could see is just generally speaking, when I have seen denial notices, sometimes counties will say that you have too many assets because maybe you haven't provided all the records they've required during the 60-month period. So they may say, either prove to us, all the transfers that happened with this account or something. And if not, we're just going to deny you for having too many assets because we can't figure out exactly what happened with this account or something. I don't think it's frequent, but I think I have seen that before.
Right. Well, you can be denied just for failing to provide
Right,
information.
yeah, I was
which
saying
is not
actually,
on
and
there.
actually, we didn't even put that on the slide. So,
Right.
yeah, so you also can get a denial just from failure to adhere to a document request, or, we are now seeing counties being a little more, I don't know if aggressive is quite the right term, but they're being certainly a little more mindful of things that are going in front of them now that a lot of the COVID restrictions are either have been lifted or are being lifted. So for instance, like if you have an annuity that's a non-qualified annuity, many offices require that the county be named as a beneficiary on that annuity to reclaim against that property upon death. It's not uncommon for that county to have the applicant prove that the county has been named as that beneficiary. And that's all contingent upon that happening, that you're going to receive that approval. If you do not do that, it would not be uncommon for that county to then issue a denial notice because you have not complied with essentially the reasons they put in their document request for you to take care of, for them to issue an approval. But as Aaron was saying, sometimes we do have disagreements with county offices as to what a transfer is, right? I can think of some in the past, generally speaking, where not to bring up annuities again, but we have had it in the past where we've had an annuity and the county has treated it as a countable annuity, where we then have gone back in the records and actually proven that the annuity actually came from an IRA or another qualified source. And if you can prove the whole period of events between the qualified money going into the annuity, then the annuity should be counted as an exempt asset at that point. But you have to be able to prove all that. If you don't, it's possible that the county may assess a penalty period against something happening with the transfer. Other things that have happened would just be things like valuations, right? Sometimes things can certainly be valued several different ways. So I don't think I can think of a active or past case where we've had this happen, but clearly, like the value of real estate, that can be very dependent on several factors. And there are many different values that can be used to determine the value of a piece of real property. So one could be the assessed value, which is a public record, can be obtained off a tax roll. Another one would be if there was an assessment done or an appraisal done against the property. So sometimes the different numbers will get thrown around, some from us, some by the county offices, and there may just be disagreement about what the value of a transfer is. So depending on how all that shakes out, there might be a period of ineligibility, not because we weren't anticipating a penalty, but maybe, what we were considering to be our best guess did not turn out to be accurate. And now the county is trying to penalize our person longer than was anticipated. And now we may have to potentially go to hearing to figure out who's actually right about that calculation.
So the big reminder is that the burden of proof is on the applicant. Okay, so the burden to show that you're eligible is on the applicant. And if you get a third-party appraisal, you're going to generally win on that. If you do things the right way, you put the time and effort into them, you're in good shape. It's when you just kind of willy-nilly go, well, this is what it's worth. That's not going to fly. So when we do things, we make sure they're documented. We make sure we have reasons. When we calculate a penalty, we do it conservatively, because if you get into a penalty period and there's a dispute, then we have a much bigger problem, which is a story for a different day. But there also is a denial for that you don't have a documented medical need, really, or enough of a medical need, let's say.
Yeah.
We don't see this very often, because if it's questionable, we will generally employ a geriatric care manager to do an assessment. So if it did come back this way, we would have essentially counter proof that the person did meet the medical standard.
Yeah. On the other hand, though, we have heard from some of our friends who are geriatric care managers that they are seeing denials for lack of medical need, where previous to, I would say, the last, 6 to 12 months, I don't think we'd ever heard of anyone really being either retained by the firm or retained by a geriatric care manager that had failed at that level, where it wasn't anticipated they would fail at that level. So it's not to say that that's still a common reason why things are being denied, but I think it's also irresponsible for us to say that we haven't heard of this going forward, because it is actually starting to happen, as scary as that sounds.
So another reason for appeals are reductions in hours. So once someone gets a certain number of hours, doesn't mean they have that number of hours forever.
No.
Generally over time, people have increasing need for hours.
Mm-hmm.
Not always. Some people get better, which is a good thing. We're always happy to see that from a person standpoint.
Yeah, it could be something as simple as somebody who was receiving services already had a fall in their house. They broke their arm, they broke their hip, they broke their leg, something like that, where it took them into a higher level of need for a temporary period of time. And then they were able to get better. And then when they got better, they went back to kind of their previous level of functioning. That would not be uncommon to see an increase in hours to cover the rehab and the other things that were needed during that getting better period. And then once they return to their previous level of functioning, then the hours could be reduced down to then better fit the level of care that they needed once they got better. So that would not be an improper use of a reduction from a plan. But that's not always that's not always what happens. More common, we were hearing things, especially when the whole managed long-term care system was getting put into place, that either plans were not authorizing hours very prudently, which is still the case these days, or especially again earlier on in the whole NLTC process, it was not uncommon to see plans that were failing because they either didn't have the enrollment required or they weren't getting enough reimbursement for the number of enrollees they were happening, and plans were unfortunately having to close entirely and then transfer their active cases to then existing plans who had the ability to take on these new enrollees. It was then being reported that at the time when people were moving plans, that the new plan would do a reassessment of those people and then offer less hours than the first plan. And again, if there had been a medical change in circumstance to justify the reduction, that'd be one thing. But in fact, really what was seeming to happen was that they were just reducing hours to try to cut costs and to try to save dollars. So that would not be a reason for a reduction. It's much more geared upon that change in medical circumstance.
So what do you do when you have an issue? It could be a reduction, it could be a denial of services, it could be a denial for any number of reasons. You then have to request a fair hearing, but you don't necessarily go right to a fair hearing. Depends on what that fair hearing is for.
Yeah. So what we're trying to make clear here is kind of once you have that bad decision, whether it's a reduction, a denial, a improperly calculated penalty period, well, then the next question is, well, what do I do next? If it's coming from a managed long-term care company, you can't just go to a fair hearing. If you go back far enough, you could do this. But then, as with everything else with Medicaid for a very long time, they're trying to make this more difficult for people to actually get the results that they want. So one of the ways that they tried to combat this and tried to essentially get behind the managed long-term care companies was that they put this new appeal process in place several years ago, where now if you get a bad decision from a managed long-term care plan, rather than filing for that hearing, you actually have to request something called an internal appeal, which is done by the plan. And then the plan will ultimately make a determination about that appeal, whether they were correct or they were not. If they are not correct, then they will issue something called a final adverse determination. Basically saying we've reconsidered, we've taken into evidence everything that you've submitted, we've reconsidered our position, we're still finding it that we were correct with that, either that reduction or that stop in service. And then essentially, once you get that final adverse determination by the plan, then you can actually go towards the fair hearing, which is then done before an administrative law judge. So you can't just unfortunately jump to a fair hearing if you're going against a managed long-term care company. If you are going against a local county DSS office for something like that calculation of that penalty period, or in too many assets, too many income, that is much more something that you can just go to fair hearing about.
Right. So the term here is exhaustion, and does not have anything to do with being tired. Okay. Although you might be tired by the time you exhaust an appeal.
That's true.
Just means that you've gone through all of your internal options. And now you can go to the old process of fair hearing. So it's important to know that if you have received a reduction of hours, you can kind of hold it off.
Yes.
But you have to know how to do it.
Yeah, so this is really, really important for probably the cases that require such action. So if you are someone if someone in your life is on Medicaid and then they get a reduction or a stop in service where they've already been in Medicaid for a period of time, if then you get a bad notice that wants to reduce or stop services, if you request further action within 10 days of getting that notice, you can actually continue to receive the services at the level you were receiving them previously and receive something called aid continuing.
Until the determination is made on who's correct, you or the plan.
Right. And for many people, this is huge, right? If they're trying to reduce your hours from 12 hours to 4 hours, and you're not going to be safe if that reduction actually happens. Right. The first step is to make sure that you don't lose the hours while all this is getting figured out of, are you right or is the plan right?
Right.
But you have to hit your mark with that 10 days from receiving that notice. If you don't, and you lose your aid continuing, then essentially what the plan says goes into motion. Now you're in a bad place until this ultimately gets resolved. And unfortunately, that can take some time.
So like all other things, essentially in the legal world, timing is important, okay? We call them statutes of limitations in a lot of other areas, but you have deadlines. And if you don't meet your deadlines, things can't be unwound, okay? So if you're asking for more hours or additional services, it's a different ballgame than a reduction in services, because a reduction is of a right essentially you've already obtained. Okay, so they're going to be treated differently. If you are asking for something you think you're entitled to and you don't get it, then you have 60 days.
Yeah. So
But if you really need it, if you really need it and you wait 45 days to request it, it's going to hurt you.
Well, yeah,
From an evidentiary standpoint.
well, that's another 45 days where you don't have that needed service. Exactly. Right. So
If you really needed it, you would have.
exactly. So if it's something that you really need, there's no reason to delay all 60 days, but you have up to 60 days. Now, this is that 60-day time period is a increase from what the old number used to be. I can't remember if it was 30 or 45, but it wasn't 60. So, so in the applicant's favor now, they've given more time to request that hearing. But again, we're typically not going to wait anywhere near 60 days.
Right. Whether it's meaningful or not, I think we could debate. Yes. So what happens in the appeal process? Well, you're going to submit information. And sometimes the plan is going to submit information. Other times they don't really bother. It's the truth.
No, it's so yeah. It's not uncommon for us, right? If we're representing someone in an appeal, where we're going to go above and beyond to just paper this as best as we can for the appeal, right? We're going to bring in anybody that we think can be meaningful to our appeal to help our position. So that could be the doctor, right? Because as we talked about in previous Medicaid Mondays, one of the changes with the Medicaid system that we're seeing is that Medicaid's continually trying to take the applicant's doctor out of this process. Well, this is a place where the doctor can be brought back in with medical records, sworn statements. I have had a doctor just jump on the phone and testify during a fair hearing if they're willing to do that and we think it would be meaningful. Other people that we've used obviously would be family members, the applicant themselves at times, geriatric care managers, anybody that we really think can be helpful to our process and to the outcome. We can bring as witnesses and we can submit evidence and testimony to just better our position to make sure that we're putting the best foot forward to get the outcome that we're seeking, whether that's more hours, that's an approval, whether that's stopping a reduction or it's stopping a discontinuance of something.
So just like other litigation, although on an expedited schedule, you're entitled to what they have against you, if you will, right?
Yes.
So you're entitled to your file, to their assessments, so you can point out what's wrong, and they have to provide it to you free of charge, which I think is important because medical records generally are about 50 to 75 cents a page these days. So if it's an extensive file, it can be a lot of paper.
Yes. Yeah, and obviously we just want to make sure that when that's happening, that you have time to review everything before the hearing. On a recent appeal that we had to do, we didn't actually receive the file in advance of the hearing, so we unfortunately had to ask for an adjournment because we didn't feel comfortable arguing against a position that we didn't know what the plan was going to be saying. So while that was not really the outcome we were looking to take at that time, there really wasn't a safer avenue to take just because we didn't have what we needed to know what we were arguing against.
So a standard appeal obviously can't languish forever, right? 30 days. What you have to really think about is how the time adds up together,
Yes.
right? Denial, appeal, scheduling an appeal,
Yes.
hearing an appeal.
Yes.
It's all kind of built to make sure that there's a long time, honestly. So the less services are given. So you have to be prepared for all of that. Yes. So.
And the plan can extend this up to 14 days if they could show essentially good cost. So again, I don't think that's common, but it can actually even go longer than that 30 days if the plan can show that there's a good need on their part to extend the time to issue that determination.
Right. And there are fast track or expedited appeals.
Which obviously some people really need, right? If it's that reduction in service or something where someone would be rendered unsafe in their home if they didn't get that clarification on who's right, that you can request an expedited appeal. If you do that, they're supposed to render a decision within 72 hours of getting all that. Again, they can be extended 14 days out, but again, obviously that's going to be a lot higher of a burden for the plan to show, because if it's being presented as an expedited appeal, they better have a really good reason why they can't turn that around fast.
And you might think, well, why wouldn't I want to do an expedited appeal under all circumstances? But all of these things are cost benefit analysis, because when can you put your best proof in?
Yes.
Because you don't want to lose your opportunity and have a record that is essentially incomplete because of the timing. Right. So all of that is done in consultation with the client. And I think, as you can see, this is a fairly complicated scenario for timing, for documents, for testimony. So it's not something that's easily done by oneself.
No, and this slide just goes to show that, like, when the plan does ask for that 14 days additional time, they have to put it in writing. They have to let you know that they're doing that. Because again, the state doesn't want you thinking that a decision is coming if it's actually been delayed. And then the plan, if they've asked for that time, they still have to resolve the appeal as expeditiously as the health condition requires for the person asking.
So deemed exhaustion is it's a legal concept. Okay, again, this means that you've done everything that you were supposed to do internally. These are administrative law concepts. All right, so you've gone through all your internal appeals, then you can go to your fair hearing.
Exactly.
Right.
Except if the plan doesn't meet their timing, right? Because as Aaron just said just a few minutes ago, timing is everything for both sides. So if the plan misses their mark, then they essentially forfeit the right to have you wait any longer. And then you will be deemed to have exhausted all of your necessary pieces, and then you can file for a fair hearing in advance. The unfortunate part is that's the only way that you can jump ahead in the process without doing the internal appeal. The external appeal is essentially to have the plan make a mistake and miss their mark. But if they do, you can hold it against them and go further in the process with that fair hearing.
So just a few years ago, you could jump right to this step. Now it would take you months to get there.
Yes.
For hours determinations and medical determinations. Again, financial determinations, you can jump right to this step because you're not receiving services because you've been denied.
Right. Yeah, and the fair hearing, that's where we actually go before an administrative law judge. I think generally everyone that I've heard of in the past, certainly few years, is still being done by telephone. I suppose that could change and go back to at least some in person, potentially, but all the ones that we've attended in several years have all been still
Even
done by
then,
phone.
though, there was a telephone recording system.
Yes.
So it is kind of a bizarre thing where there is someone sitting there, there are people taking, but you're talking into a telephone.
Yes. Yeah.
In the room with the people.
Yeah, even when you had to go down to the DSS office in person and do all of this, you were still talking into a telephone to create a telephonic record for the commissioner and whoever would be rendering the decision of the case.
Right. So we wanted to give you a potential real life example. So this is a chronic care. Okay. So this is a nursing home. So this is a little different than what would be generally appealing.
Yes.
We wouldn't be appealing hours here. Okay. But a penalty period comes up. We request a fair hearing, and we can hammer that out pretty quickly. A lot of times we work this out with DSS ahead of a fair hearing. They don't want to do a fair hearing if they don't have to either. If this is unfavorable and we still think we're right, then we do have a court process that we can implement. That occurs rarely.
Yeah, I mean, we haven't had to do an Article 78 since I've been here. I know
Since
we've had several that we thought might go to that level if it got that far in the process, but none of them thus far have.
Right.
And then the second example we have here, this is much more common, I think, of where we're getting involved typically with fair hearings at this point, which is where we have a managed long-term care plan, render an inadequate hours decision, and just going through the steps that are required to do that internal appeal, and then appeal that, wait for the final adverse determination, file for your hearing, go before the judge and wait for a decision. So unfortunately, this is now what the system has become for many people when you're fighting an hours determination.
Yeah, and I think the moral of the story is you have to just keep appealing. Because once you stop, you've lost time, you've lost rights, you've lost potential services. So don't, if this is you, keep pushing forward if you need help.
They want you to give up. They've structured all of this system with the thought that you are going to stop, you are going to give up. And if you give up, you're not going to get what you need or what you're entitled to.
Right.